Oh, I can hear you.
Thank you. Good evening, everyone.
Good evening.
Good evening, everyone. Welcome. Hi, Delegate Davis. Thank you so much for joining us. So greatly appreciated. I thought I saw Dave on here. There he is. All right, I guess we'll get started soon enough. And all right, looks like most of us, who are we missing? I don't see Sean. Is that it? I have to count because I think the rest of us are all here. Yeah. All right, well, it's 6:30. Do we want to get started? Everybody's ready. Kim, you can hear us.
Yeah, I'm gonna just turn on my camera just a second. I just have
Awesome. Yeah, no problem.
Thank you.
Yeah, absolutely. And I see the Sheriff Fredericks. Hi there. Thank you so much. Welcome. And I see Dave there. All right, I think we can go ahead and get started.
Would you like me to just start or?
Oh, we have a couple things and then we will get to you. Are we live yet?
Good evening, Jennifer. Are we
Okay,
live yet?
good evening. Welcome. This is Jeanette Ortiz, Chair of the Anne Arundel County Police Accountability Board. Thank you for joining us for our meeting here on Monday, September 26th. I would like to go ahead and call this meeting to order. And then if we can review, I don't know if members have had a chance to review the minutes. If there is a motion to approve the minutes.
Motion to approve the minutes.
Okay, is there a second?
A second.
All those in favor?
Aye.
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 Any opposed? All right, the minutes are approved, and I would just like to take a moment before we jump into public comment to welcome Jen Rogers, who's joining as staff for the Police Accountability Board. So welcome. This is her first meeting with us. So nice to see you virtually, to meet you, and we look forward to working with you. And thank you already for all of your assistance thus far. Welcome. All right, so next on the agenda, we have public comment. Is there anyone signed up? Do we have anyone signed up for public comment?
Not to my knowledge, but Jennifer, I know Jennifer's hosting this meeting. Are there any guests that have indicated that they want to speak now?
I don't see anybody raising a hand. If anybody wants to raise their hand.
I can call on you. I'll just give a little bit of wait. Okay, well, I don't see anyone, so we will move on. to our first presentation. So I'm really excited this evening to welcome Delegate Deborah Davis. Delegate Davis is the chair of the Charles County Delegation from the Maryland General Assembly. And the delegate was a member of the work group on the police reform work group of the Maryland General Assembly that ultimately drafted House Bill 670, the Maryland Police Accountability Act of 2021. And so the delegate was kind enough to join us this evening to talk to us about her work. I've asked her to chat about her work on the work group. She's also on the House Judiciary Committees in the Maryland House of Delegates, and sort of how the General Assembly arrived at House Bill 670 and her hopes for the future of police reform in Maryland. So welcome, Delegate Davis. I will turn it over to you. Thank you so much.
Thank you. Thank you so much. Thank you for limiting what I need to talk about today. I spent all day with 670. And today I learned that the part that I worked the hardest on, use of force, was stripped out of it. And it is now SB 71. So as you move forward, you should be looking at 670 and SB 71. If my assistant was here, he'd send it to you. He may be here. But yes, you must, and SB 71, the title is Maryland Police Accountability Act of 2021, body worn cameras, employee programs, and use of force. So I like the idea of talking about my role and talking about how we came to what we came to, because I titled this, How the Sausage Was Made, okay? So I want to start from the beginning. We were all in the United States when certain atrocities happened that people got really excited about it. Look, I'm going to try to be political, but I'm a lawyer, and I sat on my first police accountability task force 30 years ago. So put that in context. So timing was everything. That's how we got where we got. The protests across the country, protests at the State House. There were protests about police deaths, citizen deaths at the hands of police across the country, even in the state of Maryland, and the lack of ability to get information. The second thing was citizens coalitions. One of the big drivers in the legislation that we drafted was a group of 55 organizations, included several from your county, got together and decided that they were going to push for certain reforms, and they outlined what those reforms were. And that helped everyone organize their thoughts around what needed to be done. Key changes in leadership. Leadership is everything. We had a new Speaker of the House, Adrian Jones. We had a new Senate President, Bill Ferguson, new House Judiciary Chair, and a new Senate Judicial Proceedings Chair. So there was a lot of new people and a host of brand new legislators. I just have to let you know that. All of these happening at once is what catapulted police reform into the foreground that we know it to have been, or to the forefront in the legislature. And then Speaker Jones, as a true leader, made this a priority. She announced that police reform in the 2020 legislative session would be a priority. And over the interim, meaning after we're out of session from April to January of the next year, she assigned a work group. And it was a bipartisan work group. I was one of the members on it. I could name you others, but I can't think of it. But there were several, and we worked for months. And we were chaired by Delegate Vanessa Atterbury, who's Chairwoman Atterbury now, from Howard County. And our job was to hear from the citizens and make recommendations. And I say that because the Black Caucus took a different approach to make recommendations for legislation to be drafted. So the task force did not have a real hand in actually drafting the legislation. We made recommendations, we sent it to bill drafting, and they came out with the with the recommendations. Also, the speaker decided it was strategic to make it an omnibus bill. Usually when you write a bill, you don't include more than 3 or 4 sections of the law, but this was an omnibus bill. I think there are probably 10 sections of the law that are covered by this. And that was strategic because time was of the essence when we finally dropped the bill. Time was of the essence. We had to get it to the governor in enough time. He has 10 days to veto it, and enough time to override his veto. We were certain there was going to be a veto, which there was, and we need to override the veto while we were still in session to avoid having a special session. The omnibus bill is extensive. You guys have probably been through it already, but now you got to add the 31 pages from, no, 12 pages from the SB 71. Meanwhile, the Legislative Black Caucus established what its priorities were. And we wanted to make sure that we got, that we expanded Maryland Public Information Act. That was part of the Anton Black case. That we defined the use of force, that we changed the definition of use of force, changed the standard of use of force, that we, MPIA, use of force, they were, I'll tell you in a minute. And those were our priorities. And I feel really good about the fact that we were able to meet them. So then we, I also chaired the Legislative Black Caucus Criminal Justice Subcommittee. So we met over the summer, a bunch of lawyer legislators. And that was a really exciting team. And your own delegate, Sandy Bartlett, was on that team. And we worked with the ACLU and other lawyer organizations to actually draft legislation. So when the speaker's bill dropped, we had a draft of MPIA, Maryland Public Information Act. We had a draft of the use of force. So we had those bills ready. And we were successful in getting most of them amended onto the speaker's bill. And that's a good thing because she could have been, she could have said, no, and you're going to have my bill or none. So that's how that got made. I'm really excited that there were 4 freshmen on that. It was 7 of us, and 4 of us were brand new. 4 of us have only been through 1 session, and that was exciting. And 3 veterans, so that was pretty neat too. 670 was introduced. When a bill is introduced, it goes to subcommittee, so it goes to judiciary. And then the judiciary sends it to subcommittee, which is public safety, which I was on too. So by the time this thing got to the floor, I had already experienced 5 times. I have experienced citizen testimony, all of it, 5 times. And it was pretty stressful. I don't think any of my colleagues were on all 5 boards. And there were lots of additions and deletions. I think I counted 70 changes to amendments that were accepted to the bill. And then there was a floor fight. And floor fight it was. And I want to make it clear, if you think there's bipartisan work happening in the legislature, there isn't. At no time did any of my colleagues from the other side of the aisle give credence to the fact that people were dying and that citizens were demanding change. No one gave it. Everything was seen as tying the hand of the police. And at no time, and it was really exhausting to listen to all of it over and over again. It really was. There's even a clip of me almost crying on the television in one of my committee meetings because it was just really, really tiring. Well, we passed HB 670 and SB 17, SB 71 out of the House and Senate, pretty much along party lines. I'm not going to say that it's absolute, but very, very little movement. The Senate's contribution, in my opinion, they're more conservative. They're a smaller group and they're more conservative. Even the Democrats are more conservative. I'm trying not to be partisan. Are more conservative. So we had, since we took the lead, it ended up in the Senate. So you kind of don't know what you're going to get. So last day we have to get this thing to the governor in enough time, I guess 10 or 12 days, so that we'd have enough time for him to veto it and to get it back. So that's how use of force gets redacted out of 670, it gets put into 71. And I just learned about it a couple hours ago. It was vetoed and we overrode the veto, and that's it. That's exciting. I think what's important to you, and I want you to remember it, or to be very careful with it, is the use of force standard has changed. We learned and we heard from citizens that, and you know, that across the country, you're unable to hold police accountable for misactions because the standard was reasonableness. So the officer says it was reasonable for me to do this. It was reasonable for me to, everything was reasonable. So the standard has changed now. And this is important for you guys to know that the standard is, well, let me go over 71 really quick, if you don't mind. The officers have to take a written sanctity of life pledge, that their goal is to preserve life at all times. And the new standard is necessary and proportional. It's a higher standard than reasonable, because it might be reasonable to do something, but it wasn't necessary and proportional. And there's a duty to de-escalate. There's a duty to intervene. If another officer is doing something that they don't think is right, first aid, duty to administer first aid, and you have to document all use of force incidents. And the supervisor has to be involved. So that's really important stuff as you move forward. And thank you for agreeing to do this. It doesn't work without citizens' input. It really doesn't work. And that was the intent, was to get citizens' impact. And I also know that you're going to be trained, or you're supposed to be trained by the Maryland Police Standards Commission. And so you need to know that the standard has changed. You know, don't be trained on what's reasonable for a police officer. Don't let them take you on a ride and say it's reasonable that we act this way. They have to be retrained. And so don't let them train you that reasonableness is the standard. It's necessary and proportional, and you get to decide that. I think that's all I have. I want to hear questions and know, oh, how about my last thing that you were asking, sorry. The last thing was, what do I see in the future? Checks and balances. I've heard statements that we decided that the police weren't going to investigate the police, that if there was a fatality or a serious injury, it would go to the Attorney General for investigation. I've heard that some jurisdictions aren't sending fatalities up to the Attorney General. I believe that's a loophole, and we've got to establish some type of penalty if you don't send it. Might be problems with the trial board with hiring retired judges. I understand that that's been a difficulty for some jurisdictions. That may have to be changed. While we didn't get everything we wanted, this is an awesome foundation to build from, and we need to stay vigilant and not go back. All right, thank you.
Thank you so much, Delegate Davis, for providing that background from your perspective as a legislator and being so involved in every sort of facet of how House Bill 670 came to be. We appreciate that. And then we'll be hearing the local perspective after you. But at this time, if any members have any questions for the delegate, please raise your hand so I can call on you. I see Kim's hand. Go ahead, Kim.
Thank you for that presentation, Delegate Davis. I'm curious on behalf of our board to better understand. I mean, we live in a world of, those of us who are employed, we live in a world of constant introspection and reflection and accountability. You have to be accountable to your voters. Judges have to be accountable to voters. Where were you sensing the pushback was coming from? Because I mean, the police organization is at its heart, a protection and service organization for the community. So what was disharmonious about having, no matter what the politics are, irrespective of that, what was somehow disharmonious to any faction as to more community police collaboration?
You're muted, Delegate Davis.
Okay, I absolutely love the question, but I couldn't generalize the pushback. I believe that a certain party decided that it was their, I think it was political, it was their role to protect the police. And instead of, like you said, police community relations. I'm telling you, some of the cries from citizens was, it was shattering. I'm just telling you that people wanted answers. So I don't know. I really don't know what it was. But look, even the police officers weren't on the same page. We worked alongside minority police officers who knew that they weren't being punished, reprimanded the same way as other officers, that they had experienced discrimination. They were pushing for the dismantling of LEOBR. That was the other thing. They were pushing for that. They were pushing for statewide standards on what punishments ought to be. So even the police officers were on the same page.
Thank you. Are there any other questions from members? I do have a question for you, Delegate. So I know the counties are just starting up their PABs this year, and some of us are further ahead than others because, it's a little bit harder to stand up a PAB than perhaps some thought. And I was just wondering, since the local PABs are required, part of our responsibility is to provide recommendations to the county executive or county commissioners, county council, regarding police accountability in our respective counties. Do you think that at some time in the future that the General Assembly would consider some of these recommendations or the recommendations from the boards as to maybe how to improve House Bill 670, if you will, or continue to work on police accountability?
Absolutely. I'm already getting suggestions. I learned about the cowboy problem from my jurisdiction just a week ago. Yes, absolutely. We understand. I mean, we understand that it's a work in progress. It's also important. I'm glad I'm here because it's also important to know what the legislative intent was. I mean, you don't always see that, what the legislative intent was. And because we made sausage, I understand that everything doesn't connect all the time. I do understand that.
Yeah, it's definitely organized chaos in Annapolis during the legislative session. And, it's rare that something, the way it's introduced, ends up passing the way it was introduced. And so certainly all that feedback from the community groups and law enforcement and other stakeholders and legislators made their way into amending the original bill. Kim, I see your hand up again, or is that from earlier?
No, this is a new one that you made me think about just now, Jeanette.
Yeah.
Thank you. I wanted to ask you, Delegate Davis, I know that there are specifications about what we as PAB members have to do in terms of our training that's statutorily required. And this actually is something that came up by way of a public comment a few weeks ago. Is there something in the statute that is read to explain the kind of training that the departments have to have about the PAB or the 670 process?
What the police department should have about PAB.
I can't hear you. I'm sorry.
Your question is there training for the police departments about the PAB?
Yeah, so like one of the public comments a few weeks ago was there was some confusion about what required notice, where the notice went to. You mentioned something similar when you said that, certain things weren't going to be tried by the police and they were supposed to be elevated to the state, but that wasn't happening. Similarly, we had a public comment that asked us about, well, how do the police know that they're supposed to refer this complaint to you? Do they know who to send it to? Are they getting training? And I'm just curious to know, is there something in 670 or 671, I guess, that actually better defines the kind of training that the departments have to get so that they understand how to best work and do their fiduciary duty with the Police Accountability Board?
Yes.
Okay.
There's a deadline when everyone is to be trained, right? And the Maryland State Police Training Commission, what's the name of it? The Maryland State Training Commission is in charge of making sure that that gets done.
Okay, thank you.
They may be a little behind the 8 ball because they also have to do the standards of punishment and discipline. And so they might be a little behind the 8 ball. I think the chair is from my county.
Yes, and to your point, Delegate, they just had issued emergency regulations recently for publication as they're getting their work together. And so those emergency regulations go through quite a bit on the various standards. So thank you for mentioning that.
It's a change in the law. It's a change in the law, and police officers are held to a standard of knowing what the law is as it changes.
That's a good point. Kenny, I see your hand up.
Good evening, everyone. Thank you, Delegate Davis, for your involvement in drafting the bill and its implementation, but had a question that possibly you could help me with. The intent, or original intent as the bill was established, was that for the PABs to play a multifaceted role, or was it one-dimensional in that our role, or it was envisioned that we would just be accountable or give oversight to the police departments to hold them accountable, or be bridge builders? Or what did you envision our relationship being with actual police departments that we're giving oversight to?
It came out of the dismantling of the LEOBR, Law Enforcement Bill of Rights, right? And there was some talk about just dismantle it and leave it. Let the officers use the state employee, like other employees. They let them go through the same review board or whatever as state employees. And then I don't know where it came from, where this whole, there were bills earlier to require certain citizen review boards. People complained that they had no power. Prince George's County said, we have one, but doesn't have any power, doesn't have any subpoena power. I had a bill maybe 1 year ahead that asked for a board. So most jurisdictions were asking for a board. I'm getting to your answer, I think. So most jurisdictions wanted one anyway. And this one morphed because it came at a time when we got rid of LEOBR. This one morphed into something much, much bigger. It is not just oversight and recommendations. I don't know how I would describe it. It is, you become the enforcement arm. You actually, as I read it, you are the enforcement arm. The citizens are now the enforcement arm, and you get to decide. I'm not going to say reasonable and necessary because that's not appropriate. You get to decide for your residents. What's my standard again? What is necessary and proportionate?
Thank you. Are there any other questions from board members? Okay, I don't see any other board member questions. Delegate, thank you so much for joining us. And next we have Dave Morris, who is the Chief of Staff for the Anne Arundel County Police Department. He was the Chief of the Riverdale Police Department in Prince George's County during the time that the work group was doing its work. And so Delegate, you are more than welcome to stay on, or you can jump off. We understand that you have a lot going on. And so thank you for providing us with the state perspective on the legislation and sort of, hopes for moving forward. And now I will have Dave Morris, Chief of Staff with the Anne Arundel County Police Department, give the local perspective. And so Dave is the Chief of Staff of the Anne Arundel County Police Department, but as I mentioned, he was Chief of Police of the Riverdale Police Department in Prince George's County during this time. And so he will discuss his work with regards to, or his involvement with regards to House Bill 670 and sort of the local perspective, the law enforcement perspective of the legislation. Welcome and thank you.
Good evening, Ms. Ortiz, and I do have a PowerPoint presentation. If I could have Jennifer bring that up. And I promise this will not be death by PowerPoint. All right, so again, good evening on behalf of Chief Allard. We certainly want to thank the Executive Director, Mr. Evelyn, and the Police Accountability Board, you, Ms. Ortiz, for the opportunity to speak this evening. And just to offer some brief comments on the law enforcement perspective as it relates to House Bill 670, named the Police Reform and Accountability Act of 2021. Again, thank you for the introduction, but by way of introduction, again, I'm Dave Morris. I'm the Chief of Staff for Chief Allard here in the Annapolis County Police Department. I served previously 26 years with the Prince George's County Police Department. I retired as a police major in 2011 before being appointed as the Chief of Police in Riverdale Park, where I served for 10 years. And last September, I was honored to accept an appointment by Chief Allard to be her Chief of Staff here in Arundel County. Legislatively, I've served the last 11 years co-chairing the Maryland Chiefs of Police and Maryland Sheriffs Association's Legislative Committee alongside my co-chair, Sheriff Darren Popkin from the Montgomery County Sheriff's Office. I've also represented the Maryland Municipal League's Police Executive Association on the MML's Legislative Committee. And it's really from that experiential perspective that I'll be offering comment this evening, not reflective unilaterally of Anne Arundel County, but from the broader perspective of the Maryland Chiefs of Police and the Maryland Sheriff's Associations collectively. And it's this experience that has ultimately afforded me the opportunity to work during this past year with our county executive, our county council, our chief administrative officer, Dr. Kay, the chief of staff for the county executive, and certainly wonderful staff here in Annapolis County, and frankly, some really great folks from across the county, from all sections of our county, so that we could hopefully believe what I think is going to, humbly speaking, serve as a model police accountability board for all the other Maryland counties. I look forward to presenting this evening and certainly answering any questions that anyone may have as we advance our efforts to improve public safety's efforts to best serve our communities. Jen, could you go to the next slide, please? I want to thank Delegate Davis. I don't know if she was looking over my shoulder when I put this slide together, but you'll note that I indicate we've got House Bill 670. And while I want to take an opportunity to speak, the primary focus tonight is on House Bill 670. I want to take the opportunity to just speak very briefly about the collective police reform legislative package. Much of it has already been mentioned by Delegate Davis. These bills operate both interchangeably and in some ways are mutually exclusive and in other ways are not. And after consulting with Mr. Evelyn, I believe that it would be important just to give a beneficial, or it would be beneficial to give a cursory review of each. Each of these bills have experienced their own impediments to implementation from a statewide perspective. Much of it, frankly, due to logistical issues. Some of those impediments were anticipated, some certainly not. For example, we're now 3 months in, and there are jurisdictions throughout the state that have yet to establish their police accountability boards. Some departments we know, collectively speaking, with the Maryland Chiefs and Sheriffs, are already experiencing a backlog of disciplinary cases. So I think we here in Annapolis County need to necessarily anticipate that our Administrative Charging Committee and the Police Accountability Board may be extremely busy due to some of the delays since these cases started taking effect on July the 1st. So that's more of just a cautionary note. We'll work through the process and continue with progress. Annapolis County, I do, frankly, and I monitor what's going on in the other counties, particularly the larger counties in Baltimore City. And I think that it's safe to say that Annapolis County is well ahead of the curve, thanks in large part to a strong team of dedicated professionals that are committed to making this process work. And certainly if the members desire more information on these other bills, Senate Bill 71, which does deal with the body cameras, primarily the use of force, and the change in the standard from objective reasonableness under the Graham decision to the use of necessary and proportional, as well as Senate Bill 178, which deals primarily with the MPIA requests, and Senate Bill 600 dealing with the Office of the State's Attorney, looking into those cases involving law enforcement when a loss of life occurs at the hands of a law enforcement professional. I will say this about Senate Bill 600, of all of the bills, that bill has been probably the one that has worked well. There has certainly been some obstacles that we've had to work through. We anticipated those obstacles as we approached October the 1st when that bill went into effect. But of the Attorney General just presented last week to the Maryland Chiefs and Sheriffs on an overview of the cases that they have looked at, that they're responsible for and reported out on. And Delegate Davis spoke about the AG's office not looking at all the cases. Let me just clarify for the sake of making sure that we have correct information. The bill clearly stipulates that the Attorney General has unilateral responsibility for those investigations, and the Attorney General has and continues to work on all of those investigations. There was one jurisdiction that we know pushed back. That was heard by the courts. The courts ruled I'll just say, for lack of better words, in favor of the Attorney General's office position, and that agency has cooperated with the Attorney General's investigation as they were required to do. So that bill is, I think, of all of the police reform bills, that's probably the one that's moving more smoothly than others. But again, we'll continue to work on work towards progress. So on one noteworthy comment, I think it's important for our Police Accountability Board to know that our chiefs and sheriffs associations, including our chief of police, who currently serves as the first vice president of the Maryland Chiefs, have been actively engaged in all of these conversations regarding police reform, with an emphasis on developing good public policy. And we acknowledge that doing so becomes much more challenging when emotions are involved. And we know that some of those emotions are very deep-seated, and some of them are very warranted and justified because of past injustices. And while significant progress has been made in policing in recent years, the Maryland Chiefs and the sheriffs all agree that there's a lot of work that still has to be done. And as elected officials work on police-related legislation such as the George Floyd Justice in Policing Act, we look forward to continuing our work with both members of our General Assembly as well as our congressional representatives, because we want to make sure that what is passed is meaningful legislation that ultimately has the positive impact on policing, enhancing the public's trust and faith in our profession. So I just wanted to add that as a caveat. And again, as I've already stated, I think Anne Arundel County is paving the way for other counties to emulate. Jen, can you go to slide 3, please? So Maryland House Bill 670 is 71 pages long. It contains a lot of information, obviously. In our view, and when I say our view, I'm talking about the chiefs and sheriffs collectively, we see one of the most important aspects of this entire bill is that first item where the Police Accountability Board has a responsibility to hold quarterly meetings with heads of law enforcement agencies and to otherwise work with agencies in the county to improve matters in policing. We recognize that quite a bit of the work of the Police Accountability Board involves the Administrative Charging Committee and the Administrative Hearing Boards, but we certainly look beyond just matters of discipline, and we see this as an opportunity to work with the Police Accountability Board to examine broader trends in policing that may improve not just police services, but our county-wide services to our community. We know that a significant amount of today's societal problems default to the police, but we're confident that together we can explore means to redirect these issues to achieve a more effective and longer lasting outcome. Jen, can we go to slide 4, please? So another responsibility of the Police Accountability Board is to receive public complaints and forward those complaints within 3 days to the affected law enforcement agencies that are responsible for conducting the investigation. I also want to take and just deviate slightly and acknowledge that under the county's bill 1622, the law enforcement agencies have a reciprocal role to also report those complaints that we receive to the Police Accountability Board. And we are working on a process to ensure that we are not only meeting that requirement, but we're exceeding the requirement and being transparent. I was able to forward to Mr. Evelyn just today some very preliminary information, and I acknowledge it's very preliminary and statistical in nature. We understand that APD has put together a mechanism or a process, and we're going to take a look at that. And if that process is acceptable to the PAB, we'll work to try to mirror the process for reporting back to the Police Accountability Board complaints that the police department receives. So I just wanted to put that out right up front that we're working on it. And I've had a couple of rather extensive conversations with the executive director, both today as well as late last week. So it's work in progress, and we just ask that the Police Accountability Board members bear with us on that. Back to this slide. Upon conclusion, when the law enforcement agency forwards the investigation to the Administrative Charging Committee, they ultimately have the responsibility to review the findings of the agency's investigation, consisting of the facts and the circumstances that are supported by the evidence that's obtained during the course of those investigations. So some of the examples of the evidentiary items may include witness statements, forensic evidence, video evidence from body-worn cameras, as well as other video sources, certainly any physical evidence, documents, digital evidence, etc. So the ACC is responsible for making the determination as to whether an officer is administratively charged or not, and then they have to further determine the finding of whether whether it's unfounded or exonerated. And in those cases, it's over. The use of these two findings, I will say, is an issue that's been raised by law enforcement. Unfounded simply means that the evidence would support that the allegations did not occur. And exonerated means that the officer did engage in those actions, but those actions were lawful and justified. So what these findings neglect to address, and these are areas where we want to work with the General Assembly and certainly with our county council to address, is where the evidence is inconclusive, findings that typically result in a non-sustained. So during the chief's presentation a couple of weeks back, she provided an overview of departmental investigative findings, including those mentioned here, and including those cases that may be suspended for cause or withdrawn because the complaint was withdrawn. So these are areas where law enforcement certainly intends to offer amendments so that we can better define the process. And again, with an eye towards not changing the process, but improving it. Jen, can you go to slide 5, please? So as already mentioned, the Maryland Police Training and Standards Commission is responsible for developing a statewide matrix to be used in all matters that may result in discipline of police officer. That word "all" was amended into the language this year. It was not in House Bill 670. It was amended under Senate Bill 763. Likewise, Senate Bill 763 amended the trial board language, or in Anne Arundel County, we refer to it as Administrative Hearing Board, so that the Administrative Hearing Board will adjudicate all matters for which a police officer is subject to discipline if the officer chooses not to accept the discipline offered from the Administrative Charging Committee. This matrix has been established and has been recently approved under emergency regulations that hopefully the PAB has. If you haven't, I'll make sure that you get them. Jen, slide 6, please. So this slide indicates what information and documents have to be afforded to an officer when they appeal their offer of discipline from the Administrative Charging Committee to an Administrative Hearing Board. And it indicates the associated time complaints. While seemingly straightforward, the statute is silent on who is responsible for meeting these statutory requirements, whether it's the Administrative Charging Committee or the law enforcement agency. And because it's silent, the position of the Maryland Chiefs and the Maryland Sheriffs is that because the review and the determination of discipline is within the purview of the Administrative Charging Committee, that responsibility would follow suit. That's not a legal opinion. It's just the perspective of the chiefs and sheriffs as we look at this, again, because the law is silent. And we seek to hopefully obtain some legislative clarity as to the ambiguity of this particular provision during the next session. Again, not an impediment, just areas of that we think both the police officers that are under investigation and equally important, the public deserve clarity on. The timelines are also important to mention. Under the previously under the Law Enforcement Bill of Rights, the notification was a 10-day deadline. This has extended that 10-day deadline to 30 days, which arguably lacks expediency. That could be unfair to both the officer and to the complainant. Whether the General Assembly would be amenable to changing that back to 10 days. It's just it's a timeliness issue for all parties involved. Training for our Administrative Hearing Board members is another timeliness issue. We are happy to report that the Training Commission has trained nearly, if not all, of the administrative law judges. That was a significant hurdle. Kudos to the Standard and Training Commission for being able to accomplish that. They've also established a training program for our civilian board members and for the officers of equal rank. Certainly doesn't negate the reality that members have to be solicited, trained, and seated, but we're certainly moving in the right direction. The process, again, it doesn't promote expediency. It's just an issue that we have to deal with. We recognize that this may prove frustrating for all sides, and in particular in cases where evidence may support the egregious violation of an officer while they remain in a paid status. Likewise, concerning is when evidence would support exoneration while an officer waits due process. Just points for the board to consider. And I only mentioned them this evening for the purpose of, frankly, realistically managing both the community and governmental interests and expectations for all parties involved in the process. Jen, slide 7, please. So while this slide represents a relatively infrequent occurrence, it's just important to understand, at least from a high level, the complexity of these situations. I'm certain that our Office of Law could provide an entire presentation on this one slide, not to throw Mr. Barron or Mr. Hunt under the bus for a future presentation. But in the interest of time, I'll be brief. So when officers are charged with a criminal offense, that criminal investigation and the administrative investigation are bifurcated. This is essential to protect the integrity of the criminal investigation, as well as an officer's Fifth Amendment rights against self-incrimination. Garrity's rights protect public employees from being compelled to incriminate themselves during investigatory interviews that are conducted by their employers. These cases, again, while infrequent, will not likely involve the Police Accountability Board, at least not initially, but they may be high profile, so they may be in the news. So just wanted to mention this issue in the event that in those infrequent times where you may read about a case and have questions as to why it's not before the PAB or an administrative charging committee, it's simply because we can't do anything until the outcome of the criminal investigation is determined. That in no way precludes us from having certain conversations with the Police Accountability Board as it relates to these, at least from a high level. But again, we'd have to be very guarded in any comments simply because we don't want to risk compromising the integrity of a criminal investigation. With that, Jen, the next slide. And that concludes my comments. Certainly happy to respond to any of the members' questions that you may have, or we can certainly follow up at a later time. Certainly want to take just a brief opportunity and thank you for your time and your commitment, your experience and your talent. We realize how time consuming civic duty and responsibility is. And on behalf of Chief Alwood and the command staff here in the police department, we certainly appreciate everyone's willingness to accept this important responsibility.
Thank you so much, Dave. We really appreciate that insight in the presentation. At this time, if any members have questions, please raise your hands. I see Kim, go ahead.
Hi, Chief Morris. Thank you so much for your very comprehensive report. It was very helpful. I did put some questions in the chat because I have 3 different questions, and I apologize for that, but I was really soaking in a lot of what you were saying and wanted to just go back and highlight some questions that I had. So the first question I had was this idea of 10 days or 30 days versus 10 days. In as much as, you know, I think we can all understand that making a complaint against anyone in the police department is not something that someone does lightly, and that sometimes it might take a civilian some time to really weigh their options. The extra time seems to be more, I guess, welcoming of people who want to basically, right, stand up for themselves the way they see it and possibly ask for review of their own personal rights. So with that in mind, and you having said that there's some sensitivity about shortening it back to 10 days, you did mention, and you gave one example of how that was considered possibly unfair to the police officer. And you talked really quickly, and I understand that because you had a lot to say. I didn't really understand the import of how that, what long range effect that would have on the officer. And I wanted to really better understand both the downside that the 30 days actually proposes for either the officer or the complainant. You know, I live in a world of statute of limitations. So we've got 1 year, 3 years, 5 years, 6 years. So 30 days seems like absolutely nothing. Just it's like enough time for someone to get their act together. But I really do want to be sensitive, and we as a board want to be sensitive to somehow that how that's going to affect, you know, the officer and the complainant for that matter, and are curious to know how that would actually be a problem. And are there any other alternatives other than just going back to the 10 days?
Well, that's a great question. And so let me say this. When I look at this in the lens of both the officer and the community. So I'm very sensitive to the fact that the aggrieved individual in this is the community member or citizen that made the complaint. And so when it comes to the 30 days, everything is a matter of timing. So for example, the administrative charging committee, from the time that the complaint is filed through adjudication of the administrative charging committee, is 1 year and a day. It has to be resolved within that time frame. So for example, when I bring up the criminal case, if there is a criminal case that precludes the administrative investigation, under the previous statute, there was a provision where the clock could be stopped on the administrative investigation to allow the criminal investigation to follow through to conclusion. That provision does not exist under the current law. So with that being the case, we know that it's not unreasonable for a criminal case to extend beyond 1 year's time. So how does that negatively impact the administrative investigation? Keeping in mind that a criminal case requires proof beyond a reasonable doubt, and an officer may be found not guilty in a criminal court for the criminal charges, but could very well have still violated departmental policy. So if that criminal case exceeds that period of time for which the administrative charging committee statutorily is required to to adjudicate the case, it could negate the ability of the department to take action on a policy violation, administrative policy violation, because of the conflict with the crime. Similarly, the 30 days before the trial board having to provide copies, it's a delay, and that's a delay that impacts the citizens' ability to have their case heard more expeditiously. I'm not suggesting that 30 days is good, 10 days is better. I'm just saying that it's a change in the statute, And that change may lend itself to reducing expediency of the process. And it's just something to be aware of. Really, all this comes down to, or really what this comes down to, is we want to be able to realistically manage expectations of everyone involved. The PAB, the Administrative Charging Committee, our community, as well as our officers.
Okay, thank you. My second question relates to some other comments you made tonight. Was there prior to SB 670 a consistent standard of review that the different police departments had to use in order to review complaints?
I can't, I don't have glasses on, so I can't.
I'm
see
asking
that.
if there was a consistent statewide standard of review that it appears that in Anne Arundel County, chiefs of police reviewed all of the complaints that were filed against their officers. And in reviewing those complaints, I'm just curious to know what the standard of review is. So you mentioned, right, proof beyond a reasonable doubt is the standard that the jury uses in a criminal trial. Did the chiefs have a particular standard of review that they had to use? And was that one consistent standard statewide, or were they different department by department?
So that, again, another great question is that to answer the question as it relates to the disciplinary process, the standardized disciplinary process was the Law Enforcement Officer Bill of Rights, passed in 1974 and established a very straightforward process for investigating complaints against police officers. Where areas deviated were those agencies that had collective bargaining agreements that created not a different process, but a side process. So for example, at least in 2 counties, not here in Anne Arundel County, but in 2 counties in the state, due to collective bargaining, the chief of police did not have final authority in the discipline. If a case went to an administrative hearing board, the decision of the administrative hearing board was final. Whereas in the other 22 counties and Baltimore City, the decision of the hearing board was not the final decision. The chief could raise the discipline, the chief could accept the discipline of the administrative hearing board, or the chief could lower the discipline. So, but that was changed. That was as a result of collective bargaining agreements, and those different collective bargaining agreements, depending upon the jurisdiction. So not every police agency, there's 158 police agencies in the state of Maryland. The vast majority do not have collective bargaining agreements, so they had a standardized process under the LEOBR. Where that standardization shifted was those agencies that had collective bargaining agreements. In Anne Arundel County, for example, contractually, there were provisions that precluded the department from holding a departmental hearing until a criminal case was adjudicated. But that was also a provision within the state law. But the chief, so the process for review was standardized by the LEOBR. Any modifications would have been as a result of collective bargaining agreements. But the process here in Anne Arundel County, very simply, was once Internal Affairs conducted the investigation, Internal Affairs would brief the chief and his or her command staff on the outcome of the investigation, and then discuss appropriate disciplinary actions in accordance with past practice and past precedent here in Anne Arundel County, in order to lend consistency to the disciplinary process here in Anne Arundel County. Does that answer your question?
No. So let me ask it again a little differently.
Okay.
One, I want to make a comment about what you said about the tolling of the criminal case. And I can see how that's problematic, right? Because I assume that they're not the same rights for the administrative case that there are for the criminal case, and that there's, Fifth and Sixth Amendment rights, including the right to not speak being one of the primary ones. And that could be problematic. And this is just, at some point it'd be great to follow up on this. It seems like if the defendant is the police officer and the defendant wants to make sure that they're not compromised in that way, the Speedy Trial Act could be told by the defendant with no problem. So I don't know if that's I understand that what you're saying about the statutory organization and the construction, and I definitely think it's something worth looking at, but it seems like there's at least that as an opportunity, because there's not a reason for a court to deny, right, a defendant's request to toll the speedy trial. But that aside, what I'm really asking you is, what is the standard of review? So if I'm a chief, right, and irrespective of where I am, if I'm a chief and I'm looking at this complaint, do I have to, in order to sustain it, do I have to be convinced by clear and convincing evidence? Do I have to be convinced by preponderance of the evidence? What is the standard that I'm using to decide whether or not I believe the complainant or not?
Yeah, so the standard as outlined under LEOBR and outlined under House Bill 670 is preponderance of the evidence. So slightly more or slightly less.
Got it.
So when the evidence, sometimes evidence is clear and convincing, one way or the other. Sometimes it is not, and it comes down to, in many cases, this is what the complainant says, this is what the officer says, and there's no additional evidence to be considered. And in those cases, typically those are in a non-sustained. It can't be proven one way or the other. I will say this, that the body worn cameras have been significantly important, as we anticipated they would be, in showing most of what occurred in these incidents where officers are involved in these critical incidents. Sometimes the video is blocked because of where the officer is wearing it. Sometimes the audio becomes distorted. There's a whole host of things. A body worn camera is a tool, not the tool, but it's been our experience so far here in Arundel County, and I think it's safe to say that we've seen it with those agencies that are using body worn cameras, and many of them have been using them for several years, that they are instrumental in being able to provide a better picture of what occurred and whether or not the officer's actions were justified or whether they were not, so that appropriate action can be taken.
Thank you for that. My last short question.
Can I just let Kenny jump in here
Yeah,
for a minute?
sure,
I see his
sure.
hand up, and then if anybody else, and then we'll come back to you. Thank you.
That's
Go ahead, Kenny.
Thank you, Chief, for your presentation. Quick question. When an officer might be terminated for a non-felonious act, is it the intent that that officer's name will go to either a state or national database, or some process where they can't be rehired with another agency? Or what happens at that point?
So I can't speak what's happening on a national level. There's certainly been conversation about that, and it certainly is problematic. And we have seen that play out here in Maryland, where individuals were hired that shouldn't have been hired. And I'm not going to go into the details. I don't think that's relevant to this conversation, but we've seen it play out. But if an officer if their employment is terminated with a law enforcement agency in Maryland, the agency is required by law to complete a personnel action notification form and stipulate very clearly what the reasonings were for that separation. And that's filed with the Maryland Police Training and Standards Commission. So that form, for example, and it's a personnel action notification form that has to be filed anytime that there's a change in a personnel action. So if an officer changes their name, we complete that form. If an officer is married and there's some sort of a change, that form is completed. If an officer retires in good standing from a law enforcement agency, that form is completed. So it's completed for a host of reasons. But in your specific question, if an officer is terminated, or if they resign while under administrative investigation or a criminal investigation, they are flagged with the commission by checking the appropriate boxes saying that they resigned under that duress, for lack of better words. And the commission maintains that, so that any agency in the state of Maryland that fills out an application for certification to hire Dave Morris is going to see that whether I retired from Prince George's County in good standing, or whether I retired while under administrative investigation, and then they would have to appeal to the Maryland Police Training Commission for any sort of a waiver before hiring them.
Thank you.
But
I
again,
have a follow-up.
that's local.
I have a follow-up to that, right? That's local. because I know of the case that you're talking about that happened on the Eastern Shore where an officer was hired from out of state. And so in that situation, information was not shared with the Maryland Police Standards Commission. And so is there a way, and I'm sorry if you were kind of alluding to that and I just missed it, for the state, for the Maryland Police Standards Commission to receive personnel records or whatever it may be from out of state and not like rely on a local police chief, for example, to provide that information, as was in that case in which information was withheld?
Well, I don't know that the Maryland Police Training Commission can require another state to turn over records because their records would be governed by their personnel laws. However, and I want to say that it's in 670, and I apologize if I'm mistaken, but in one of these police reform bills, there is a requirement, and I think it's in 670, there is a requirement that applicants for law enforcement agencies in Maryland have to reveal what other agencies they may have worked for or applied for. And they have to do that under the penalty of perjury.
Thank you.
And if Mr. Hunt is on here listening, he could probably confirm or clarify in case I've misspoken. I don't think that I have.
I don't see him, but thank you so much for that additional information. Were there any other questions? I know, Kim, you have additional questions. Anybody else? Okay, Kim, go ahead.
I feel like I'm the question lady. So the last question on here I had was, is there a reason, is the reason why the complaints are withdrawn, is that either known or tracked?
So once a complaint is filed, it's in our IA Pro. But if a complaint decides not to pursue the complaint, then we still have the option. The law enforcement agency always still has the option to move forward on investigating a complaint. So, and just as we have the option of investigating anonymous complaints, even though House Bill 670 stipulates that the complaints have to have the complaint's name and contact and so forth. If we had a complaint come to us that Dave Morris was engaged in criminal activity and conspiracy to commit fraud schemes and things of that nature, it would be incumbent upon this department to at least initiate an investigation into that complaint about that allegation. So even if a complainant were to withdraw the complaint, if we think that it warrants further investigation, we'll do it. The question becomes how much information can we get if the complaint's not willing to cooperate? And in some cases, the complaints withdraw the complaint because they don't want to get further involved. Sometimes they've had second thoughts. Sometimes after perhaps reviewing body-worn camera footage, they realize that what they've alleged didn't actually happen the way they alleged, and they choose to withdraw the complaint. So there's a whole host of reasons. We don't encourage that. We encourage folks, if they feel that they have a legitimate complaint about a police officer's misconduct, we want to hear that complaint so that we can investigate it to conclusion. But we can't compel individuals to cooperate with us in any investigation. If they choose not to.
Understood. Do you have any idea percentage-wise how many of the complaints that are withdrawn actually go forward nonetheless?
Well, I can tell you that I just provided some information to Mr. Evelyn this afternoon regarding 10 complaints. Of the 10, one was withdrawn, but it involved one was withdrawn. I unfortunately, because it's an open meeting, I can't go into detail.
That's fine. All right. I promise you, this is my last question.
Okay, because we have the sheriff waiting
Yeah, I
to
have
do
one
his
last
presentation. Okay.
Just one last, because I really do, I want to, in fairness to Chief Morris also, I had asked earlier, Delegate Davis, what was the sticking point? You mentioned that there was a jurisdiction that didn't want to refer the loss of life case to the state. From your perspective, to the extent, and politics aside, but to the extent there was any pushback to 670, from police agencies, what is the real fear there? Or what is the concern there?
Well, as I stated in my comments, the chiefs and the sheriff's associations, both of them here in the state collectively, have been at the forefront in all these conversations. I can state that I have testified many times in Annapolis on bills. I think Ms. Ortiz has probably either been part of or witnessed or seen that testimony. And the position of the chiefs and sheriffs, generally speaking, is to support bills. Because we think that it's important to be at the table, to have a voice at the table. When we see legislation that we think is just erroneous or could lead to bad public policy, we have an obligation as law enforcement professionals in the state to share that information with our delegates and our senators. We see our role primarily is to educate. A lot of times, as you might imagine, Ms. Ortiz, I think mentioned it earlier, it's controlled chaos of what goes into Annapolis and what comes out of the shredder are two different things. Is that a fair statement?
Absolutely.
So when we see what we think is going to have whether certainly unintended consequences, we think that we have an obligation to share that information with our delegations, and we do so very candidly. We think that it's important to have those frank discussions. I think that it's safe to say that my experience in Annapolis has been generally very positive. Certainly, and I will also state that I know that the testimony that's offered in Annapolis in those 2 or 3 minutes is really, it's the public facing, it's the conversations that go on in those closed door sessions or with the subcommittees where the work really gets done and we can get down to brass tacks. So I'll just speak, I'm not going to speak for anyone other than the chiefs and sheriffs in this case, that we've been at the table. We'll continue to be at the table. If we think that there are consequences that could negatively impact law enforcement and our ability to provide good public safety services for our community, we're going to speak on those and we're going to be candid in our conversation. Likewise, if we think that there are ways to improve legislation, we're going to offer those improvements, and oftentimes we do, and oftentimes those amendments are accepted and incorporated into the legislation.
Thank you.
Thank you so much for answering that. Were there any other member questions? All right, well, thank you so much, Dave. We really appreciate you taking your time this evening to share the local perspective regarding the work of the PAB and all of the laws, including House Bill 670, which kind of basically, advise how we will function and how Police Accountability in Maryland will work moving forward. And thanks again to Delegate Davis. You are welcome to stay on, but we understand that you both have a lot going on, and feel free to jump off. And I just want to say before we bring on Sheriff Fredericks, that we will, continue, the board will continue to have different perspectives from the community. As we have previously discussed, we wanted to provide a state perspective and a local perspective on the new laws in place that impact the work of the PAB, the ACC, trial boards, and police accountability in the state. And we look forward to having perspectives from community groups and stakeholders in future meetings. So that is absolutely to come. So thank you again. And so now I would like to welcome Sheriff Fredericks, who will be providing a presentation to the board. He will round out our agency presentations. We previously heard from Arundel County Police Department, Annapolis Police Department, Crofton Police Department, and Anne Arundel Community College Police Department. And so we asked the chiefs to speak on agency leadership and structure, crime statistics, summary of complaints, overview of internal investigation process, efforts made by the agency to build community relationships, and a mini SWOT analysis. So welcome, Sheriff Fredericks. We really appreciate you your patience and waiting to speak this evening. And we really appreciate having you tonight, and go right ahead. Thank you.
Well, thank you for having us. I greatly appreciate the opportunity to speak here. I know we were on the slate for August and missed that date. And I appreciate the opportunity to make it up here. So thank you. With me is Colonel Francis Toohey. He is my chief deputy here in the sheriff's office. I am the elected sheriff. He is the appointed chief deputy. Everyone else in the staff from captains on down are sworn members of the agency, all uniform. I'm excited to give you a quick presentation of us. We're a very unique office, a little bit different than our law enforcement partners here in the county. As a sheriff's office, we do a different function in law enforcement, although all of our folks are sworn to the same level as our counterparts in the county police department. We have some different duties. So instead of working for the legislative branch or the executive branch of government, we work for the judicial branch of government. We work out of the circuit court and serve functions for them. So it's a little bit different. What I hope to do here tonight is to give you a little bit of perspective on the things that we do as the law enforcement arm of the judiciary. So we don't work for the executive branch of government. Like I said, we're an office and we're not a department of county government. So a little bit different. We work out of the courts, and with that, we're responsible for the protection of the circuit court. So all of the members here in the court building, the judges, we do some investigations, but not many. So for your police, they're your 911 response. They do all your criminal investigations. Most of the investigations we handle here would have to do with judicial threats and threats against the court. So that's pretty much the extent of any criminal investigations that we would do. We have 85 sworn, plus myself and the colonel. We have a total of 122. So we have about 35 civilian positions here that are full-time or part-time, only a few part-time positions. Other than protecting the circuit court, just to let you know, for the volume, well, we're a very busy court in the state. We screen, we're a 100% screening for the safety of our patrons here. We screen about 24 to 25,000 people per month coming into the court. We transport inmates from the county detention center to their court date here. We also operate a detention facility within the circuit court building in Annapolis. We can hold up to about 88 detainees in one day there, and we do that with a relatively small staff. I'd have to say when both the colonel and I come from 26 years with the county police department before I was elected in 2018, and this office, all those small, they are mighty. They do quite a heavy lift for the county in the law enforcement community, and we've become very proud of the jobs they do here. And with the transports for prisoners, that detention unit operates with only about 7 deputies, and we transport less than we used to pre-COVID, but we still have a lot of movement in and out of the courts. We issue also from our field operations. We basically have 2 sides: security operations and field operations. All of our field deputies, we serve court documents for the circuit and district court, and that includes domestic violence paperwork, warrants, and landlord-tenant cases, so evictions. We issue more than 50,000 documents, hand-delivered documents every year for the court, and we serve on average about 2,200 warrants per year. So that's just to give you kind of a quick overview of the agency and some of the things that we do. And I think Jen, you have our slides prepared for us to go over the rest of our information. Perfect. So there you go. That's just a quick breakdown of the leadership structure. Not significant compared to our police department friends. We're about 1/10 the size of the police department. So you can see there we have the colonel and I. We have 2 captains positions, 3 lieutenants, 7 sergeants, and 2 civilian manager positions. One of them is a new position for public information requests under our new body worn camera program. And that one isn't quite filled yet. So if you can go to the next slide. So that's a quick org chart for us, just to kind of give you that breakdown I just talked about. It's a pretty simplistic org chart, but we're a pretty small agency. You can go to the next one. So summary of complaints. So For us, all of our criminal statistics are reported through the police department. So we utilize the police department's records management system, their automated reporting system. And within their automated reporting system, one of the most significant things we do is entering the court documents, and we do that for our warrants through their system. So all of the crime reporting, any statistics that we might have, which are very few for crimes out of the court, they go through the police department. So this breakdown here is getting more quickly into the summary of our complaint system here. When we got here in 2018, December 2018, I was sworn in. I can tell you when we did a review, the internal affairs system here in the sheriff's office was non-existent. Basically, there was no internal affairs unit. With the police accountability coming into play here, and I won't jump into my SWOT analysis too much, but to say that we've now started an internal affairs unit here, which I'm very excited about, and that will serve two purposes: both internal complaints and our compliance to state requirements and standards. So what you can see here is in 2017, no citizen complaints, no internal complaints were recorded. And like I said, when we got here, what we found was a logbook that looked like a high school kid's journal, from years ago that just had handwritten entries in it. We've digitized that, and one of the things that we're also looking at doing is jumping onto the county contract too for IA Pro to actually get this agency into the modern world with having internal affairs complaints that are used through a modern software system. In 2018, no citizen complaints, one internal. And what you'll see here now is a change 2019, 2020, and 2021. All those slight in number. What you'll see is that we're holding some people internally a little bit more accountable than used to. We brought some different standards here into the agency, and that's basically what you're seeing there is just a quick summary. When you get down to 2021, most of the complaints are generated within the agency, and those are from review and assessment administratively. So a couple of training and a couple of reprimands and counseling there. You can go to the next slide. So for that summary, just to give you a little bit of breakdown for the citizen complaints there, most of the things that we usually get because we're working for the judiciary is some phone calls that don't rise to the level of anyone making a formal complaint, but we wanted to include them in here just to kind of give you an idea of the full spectrum of some of the calls that we get. And a lot of times it's a misunderstanding or a lack of understanding of court processes and documentation. So we'll get something, someone that might call that says that, the deputy left this paper and they didn't explain it or something like that. So very minor stuff. And usually it's a misunderstanding of some of the paperwork that some people have received. The internal complaints you see there, most of those are generated usually on view, things that we'll see, some failure to do things in accordance with our general orders. And we've had a couple that were care of equipment issues that are also very minor. Use of force. One of the things that we had an option to do in 2019, soon after getting into office here, was to get onto the FBI National Use of Force Data Collection Standards. We did that. And what we're finding though is that most things like our minor taser deployments, some hands-on techniques that are utilized for arrests don't meet the standard. We've only had one reported use of force that met the FBI standard, and that was canine use that resulted in some stitches and hospital stay for someone. So we're actively attempting to report some things, but very happily I can say that we haven't had to meet that standard too many times here. So we've only met it that once. You get the next slide, please. So for the complaint process, one of the things I wanted to make sure we included here is some supervisor training. So as part of the process, you can't follow a process if you don't know what you're doing. So one of the things that we did and we brought over from our knowledge from the police department was the use of a supervisor's complaint reception handbook. We instituted that here pretty early on, and it's been great for us because it standardizes and kind of makes uniform the process before the invention of the PAB for us here. It formalized our process ahead of schedule. So the transition here to the PAB format is going to be relatively simple for us. And we're pretty happy that we got that instituted early on. With receiving complaints, when we first got here, basically you had to call in and a form was filled out. We've expanded that now. So obviously, traditional methods, in-person, phone, email, standard mail are all, the ways that you've been able to do it in the past. We added the online feature, and we also added a mobile app for Anne Arundel County Sheriff's Office. And through that app, you can also access not only information about the court, some other programs that we've started, but also file a complaint through that as well. So we're very happy to be able to extend that out to the public. Most of the people age 18 to, I believe that the age is 55. I believe it's like 90 or 93% of the public has a smartphone, and that we thought that the mobile application was very important for expanding that ability to make a complaint or a compliment. So for the complaint reception and investigation, very simple process. When we instituted the supervisor's training manual, you can go into any of we now have 2 facilities, one on Commerce Park Drive where we are now, and the courthouse. You can go into any of those facilities, make a complaint. We'll fill out a complaint reception form regardless of how you make the complaint, and then review it for a violation. And that's anything from regular misconduct, minor stuff, rules. It doesn't matter, criminal. We'll review it, and then we'll start the formal process. The one good thing about half of our agency working in the courthouse is the courthouse camera system is in place. We also have a mobile camera system that is in each of our 3 prisoner transport vans, and we have now instituted body worn cameras. So pretty much every aspect of what we do is covered by camera. We think that is a wonderful piece for accountability to the public. And then once we've secured video, which many times there's going to be video for us here in the sheriff's office, then we'll initiate any investigative process with that new investigative unit that we've started here, and of course report to the PAB. You can go to the next slide. So we get to the community relations piece. The previous efforts weren't much. When we got here, there were about 2,000 followers on the Facebook page. The county website was the primary used social media, if you can count that as social media. Wasn't much info out there about the office, and very few attempts to get out in the community. Mostly what the previous administration did was go to parades, and that was about the extent of their outreach. Like we said, we went to the sheriff's app, was one of the things that we added, which was a big part of our outreach, because not only did it put some more of our information out there, but it gives people an avenue into the sheriff's office as well. So in our recent efforts on top of the app, one of the biggest things has been to educate the county administration on how we fit into the law enforcement environment here in Anne Arundel County. I don't think that a lot of people, as we're trying to do tonight, is to educate the PAB on what we do and how we operate. And one of the things we found is to get the resources to expand our community relations, we have to educate. So, that's been a big piece, is to be constantly talking to the county administration, regardless of, outside the budget cycle. We're always talking to them to try to get them to further understand how we operate and expand our ability to get out in the community. One of the things that we're most happy about is to see up here this safe surrender program. So one of the things we're finding was with outstanding warrants, and we're responsible for circuit court warrants and district court warrant service here in Anne Arundel County. We have a memorandum of understanding with the police department that's existed for 20 years. And we are the only sheriff's office in the state of Maryland that has an MOU like that, where we take primary responsibility of the district court warrants. In every other jurisdiction, it is the basically the agency that, whatever agency does your investigation and 911 response, whether it's a PD or a sheriff's office, they do those district court warrants. In Anne Arundel County, we do them. So we actually house, we're the repository for all warrants in Anne Arundel County that are generated through the sheriff's office, the court, or the police department. So one of the things that we did was we developed this safe surrender program. So there were a couple pieces to that. One was to get that information out more. So as far as warrants. So we started an online warrant database. We expanded that to the app. So through our online outreach and our mobile application, there are about 9,000 active warrants online. Now they are not brand new warrants that are new as of today to 6 months old. Those warrants are still actively sought persons. So there could be an officer safety issue if you put a warrant that was just gotten today online, and then someone finds out, that they have it, and then the officer comes and knocks on your door, or deputy. There could be an officer safety issue there. So what we did was we said some of these more historic warrants that are 6 months to 10 years old, we're going to put those online, and we're going to allow citizens to go on there and find out if they might have an old warrant that you don't know about. More than 50% of those warrants are old traffic warrants. So many people, there's so many instances you'll see on social media, YouTube, where there are these negative encounters because a lot of times people they just don't know they have an old warrant. So one of the things we wanted to do was we wanted to start the safe surrender program, put these warrants online, allow people to find out that they have a warrant online through our website and through the mobile app. Is a very detailed explanation of a process. Call in, you can make arrangements for a meeting with a deputy in a safe place, either a district police station, at the Central Processing and Holding Center at Jennifer Road, or at one of our 2 facilities, and turn yourself in a safe manner. We expedite that process, and as an incentive for the safe surrender program, we issue a letter from me that says that they participated in this program. By participating in the program, they reduced the possibility for negative interaction between a sheriff's deputy and the citizens, and that it also not only was it helpful for the process itself, but it was safer for all parties involved. And we allow them to have that letter, and then they can use that for whatever purposes. They can give it to an attorney, show it to a judge, and maybe it'll help mitigate their case. What we found is that that we've more than doubled the number of turn-ins per month that we used to have. We averaged less than 20. Now we average about 45 turn-ins per month. We've had as many as 67 turn-ins in 1 month. And that's phenomenal for us because that's a couple of hundred warrants per year where we didn't have to go out and seek someone, and someone didn't just give us a tip and we went and banged on someone's door, to possibly create a negative interaction. So we're very happy with the success of that. And one of the things I wanted to point out was more than 60% of those turn-ins are either African-American or Hispanic folks. And I think that's been a huge bonus for us, not intended, but a bonus because it's allowed a safe turn-in process and allowed someone to get their day in court. You can go to the next one. So as part of the continued efforts, I've talked about the mobile app a little bit there. So we've expanded our Facebook and really, I mean, you can't get away from the use of social media these days. So we've expanded some of our programming. We have an SPCA program where we try to help them get dogs in their program adopted. That is bolstered our Facebook reach. We put out a lot of agency info, press releases, job announcements, and now we've expanded to over 5,000 followers on that. We have another more than 1,000 through the app. So we are trying as much as we can to expand there. We have expanded the number of community events that we attend with our deputies. Not only now are we, attending parades like they used to do, but now we're there in the community doing events. We've done back to school drives for school supplies. We've done just a host of different things and have gotten more deputies into the community. And one of the reasons we couldn't do that before under previous administrations is because they didn't have a take-home car program. So we expanded our take-home cars for deputies, and now we're able to get more of them out in the community and doing community events. So that's been a great thing for us. An interesting thing that we did in light of COVID was we were contacted by the Arundel Community Development Services nonprofit here in the county that was giving aid under CARES Act money to folks who couldn't afford to catch up on past rent and lacked services for eviction help. So they asked us to partner with them and create a database that basically gave them some foretelling of scheduled evictions every month from our deputies, and we kept that up to date daily. And they were able to help a significant number of people stave off eviction and keep them in their homes, particularly during this pandemic. And we thought that was a great relationship that we were able to form, and we still share that relationship with them now. One of the other things that we did was we volunteered to get on with the Open Arundel online statistic program that the county started, and share some of our performance data online as well. Probably one of the biggest things that we've done that really the colonel was responsible for mostly was implementation of the body worn camera program. I'm super excited about this because we are 3 years in advance of the state requirement for getting body worn cameras. Most large agencies, or some of the large agencies like Hartford and Arundel, were required to do that early on. All other agencies were smaller agencies or 2025 implementation. And happy to say that about mid-July, we got our program off the ground and running. We had sought funds from the state for grants, and we were able to get some grant money, and then the county kicked in the remainder of that. And we've gotten on with the body worn cameras, and we think that it's going to be a great program for us for accountability in the public. You can jump to the next slide, please. So our quick breakdown on analysis here for SWOT. The one great thing about our agency is you saw that we don't have a whole lot of citizen generated complaints. The avenues are out there, the portal's out there. There's a portal obviously for the PAB. There's a portal for us, at least on our online website, that you can file a complaint, the app, and of course in person. And with our agency size, we think that the one benefit for us with the PAB structure is that although we think that we should be dedicated to making sure that our investigations are timely and done in a fashion that's structured every time, so they're done the same every way, or same way every time. We think with our small agency size, we're able to do that with just having 1 or 2 investigators. I think that's a boon for us. We actually, in advance of any requirements for police reform legislation, completed de-escalation and duty to intervene training in 2020. So we're coming around to where we're probably going to be doing some refresher training on that. And one of the things that I know Dave Morris mentioned, his heavy involvement with legislative efforts, and I've actually been involved with the Chiefs and Sheriffs Legislative Committee for the past 3 years. So at least I'm familiar with where we came from and where we're going with this process, and I think that's helped me easily translate that into some good direction here in our agency. Weaknesses for us: timely investigations and personnel trained to do such investigations. We're finding that we want to make sure that we have a couple people who have gone through a formalized internal investigation school. The person that's doing our investigations now this is his second career. In his prior career in Prince George's County, he was an internal affairs investigator there. So we're very happy with having him here with us. We talked before about not having a professional standards or IA structure conduct investigations. So that was one of the lifts for us, was to have to be able to create that. So it is a new structure. So obviously, we're willing to make some changes to that, and we'll change as we deem necessary. The staffing increases, we had asked in this budget to actually get additional deputies to staff that professional standards unit. We were looking for 2 deputies for that. We did not get that staffing in our county budget, so we've actually had to pull that deputy from some other very important things here to staff that position. So everyone counts here because we kind of operate with a skeleton staff, and we're trying to expand that through the budget process. And then that final bullet there, implementing all the changes across our policies, practice, training of supervisors. We don't have a huge staff here, so we all do a lot of hands-on work, including myself, with policy updates and making sure that that our training is up to standard. So we're constantly working on that as well. You can go to the next slide. So some opportunities. I mean, there have been some great opportunities that have come out of this reform legislation for us, justifying expanded training for us. So we're in our new facility here. It's a 14,000 square foot facility on Commerce Park Drive, which is off Bestgate Road near the Annapolis Mall. We were basically being squeezed out of our space in the court to make room for expansion of court processes, and thankfully the county was foreseeing enough to be able to get this facility for us and some other agencies here. Police body worn cameras in this building, as well as some fire and other courthouse staff. So that's been a boon for us. Now we have a modern training facility here. Because we don't have a large budget for training, we now having a formal training facility, we can now host training here that we will be able to take advantage of. So when you're hosting a class of maybe 30, 40 people, usually you get some free slots in there and for hosting. And that's one of the things that we look to take advantage of now. That other bullet there, planning for technology and equipment. For us, we mentioned the IA Pro, which was the internal affairs software. The Colonel has a great tech background, and he's been working with OIT to get a lot of improvements for us when it comes to that. Obviously, IA Pro is going to be a big plus for us, and we're on the schedule to start that as well. New taser technology. So not too long ago after we got here, I mean, we identified that they had just not been on technology replacement contracts. They hadn't been doing a good job of following up. One of the things that we did was we started to get on a better technology rollover schedule. So the new taser contract that we are under, we have modern taser technology, and anytime you can improve your less lethal technology, the better off not only the deputies but the public safety is in general. So we're very happy to be able to modernize some of that tech as well. And again, I mentioned the body worn camera program in advance of the state requirement. That's just something that I think is going to play very well for our accountability purposes. And adding that investigator was another great opportunity for us. The threats, I think, are pretty simple, but not many. For us, there's an aura around police reform with potential officers and deputies. And I think that's anywhere that there's new uncertainty with this. I think that is always going to impact your recruitment and retention. We're working on that. We have to recruit against our law enforcement brothers and sisters over there at the police department, as well as some other local agencies and the big agencies around us. So it makes recruitment for us very difficult, and we think that the unknowns, I guess, for some people out there with police reform have caused some consternation as well, and probably affecting some of our recruitment efforts. And then just simply the uncertainty of the disciplinary matrix, and that's just from speaking with some of our union reps here. I think it's just not knowing the process, and we're kind of all in this, and you all as well. As we feel it out, I think it'll smooth itself out, and we'll see that that this process is very workable, that probably the matrix isn't very far off of some of the discipline that would have been had in the old processes under LEOBR. Yeah, so I think that's some pretty minor stuff, but I think that pretty much sums up the formal part of the presentation, and I'm happy to answer any questions.
Great, thank you so much for that very comprehensive and thorough presentation. If there are any board member questions, please use the raise hand function. Oh, someone clapped, but I can't attribute that to
They
someone.
clapped because there was no hand raising. So listen, I know that, so I'll just say this real quick. I know that there's usually some confusion and, some just a lack of understanding of the sheriff's office. And I welcome at any time, whether it's this meeting, call me in the office. If you have any questions at all about us and our processes, I'm always happy to answer them because I want people to know as much as they can about the sheriff's office.
Right.
Absolutely, and thank you. And thank you for sharing all the ways in which we can obtain and the public can obtain additional information about, the work that you do in your office. I see Barney's hand up. Go ahead, Barney.
Learn how to unmute my microphone first. There are two questions that come to mind for me, is whether or not the Sheriff's Department should in fact determine to the extent possible why citizens are withdrawing their complaints to ensure there's no bit pressure being put on them. I understand you're limited in how much you can get from a citizen, but any documentation or contact subsequent to the withdrawal, you keep records of that. That's one question. The second one has to do with your warrants and the work that you do with domestic violence cases. Often we hear about domestic violence cases, restraining orders, for example, not being complied with. To what degree do you monitor those cases to ensure you follow up to make sure that the complaints are not, or the restrictions are not being violated?
So I guess I'll jump to the DV question first. So we receive any documentation from the court and we serve any of that process. We do have 2 domestic violence deputies assigned to each of our field operations teams. So we have basically 2 teams that serve warrants and domestic violence. They actually become very familiar with some of these people who unfortunately go through the process more than once. So they can either contact the sheriff's office, the police department, or if the case is already before the state's attorney's office, the advocate at the state's attorney's office. If for some reason the order is not being followed, and there will be follow up with that. So there's always a detective assigned from the police department as well to follow up on these cases, and they're usually the one that's going step by step with the victim in the case to ensure that. And usually that's the first call is going to go to the police department, but we will take any call anytime they want to call us and let us know that something's not being followed, and then we can follow up on our end either with the detective assigned to the case or find out if there's additional paperwork through the court.
So I'm Colonel Toohey. I'm going to add something to this. So basically, through our memorandum of understanding with the police department, and we're serving their warrants for them, that basically keeps them available for 911 calls. It also allows our investigators to continue their investigation rather than wasting the time of trying to locate someone that may not want to be located. So we take that burden off. So we become sort of the middleman in their investigation. So they'll do their investigation, maybe obtain a warrant when they've identified the suspect. We'll serve the warrant. And then once the warrant's served, the police department gets notified that the warrant was served. So if they want to meet with that person, whether they were incarcerated or released on bail, they get that opportunity to do that. So we're kind of like just in the middle to keep the police department focused on investigations and response to emergencies and serving the public. We kind of do that, the paperwork for them, if that's a good analogy there.
Mm-hmm. Does that answer the DV part, Mr. Gomez?
It does to some extent. It doesn't show me a proactive effort to follow up on the domestic violence issues. Thank you for your response.
Yep. Well, like I said, there's two arms here. It's you have us working for the court side, and then you have the police department doing that investigative side. And that's a heavy lift for them, is that follow through with the state's attorney's office. So in the first part, for complaints received, one of the things that we've talked about in the process that we're following with the new PAB structure is to make sure that when we do receive a complaint, even if that complaint is withdrawn, we'll still have the initial complaint reception form that we'll maintain, and then that way we'll have record of whether or not a complaint actually came in and that disposition. So that won't go away. If someone withdraws the complaint, it'll be marked that it's withdrawn.
All right, thank you. Were there any other member questions? Okay, I don't see any. Once again, Sheriff Fredericks, thank you so much for joining us this evening. We'll see you again in a few months as we have our quarterly meetings with the various agencies. You are welcome to stay on, but we understand if you need to jump off and get back to work. Thank you again.
Thank you.
All right.
Appreciate it.
Have a good night. Next on the agenda is the Executive Director's report. So we will have a report from Jansen on the quarterly review of complaints. Thank you.
Hello again. So I'll try to be as brief as possible. However, if there are any questions before I go on to the next section, please be sure to jump in. And I say jump in because I'll be looking at my notes. So I want to make sure that it's not rude to just say, hey. Anyway, so beginning in terms of quarterly updates, as you know, there were 6 complaints, and I know that you all have access to the portal now, or to the information, to the place where we're holding all of the information that comes through the portal. All of the 6 complaints that were entered into the portal, and those complaints, they were all submitted against the Arundel County Police Department. All of those complaints occurred before July 1st, 2022. One was in 2010, another was in 2015. Now, those complaints, particularly the one in 2010, it was in fact investigated. Matter was presented to the state's attorney's office, who declined prosecution. The one in 2015, like I mentioned, all of those incidents are viewed as ineligible incidents under the law, because they occurred before July 1st, 2022, the establishment of the legislation. So additionally, the incident must have involved a member of the public in actions of a law enforcement agency. So many of them, like I said, one was declined prosecution. The others were all incidents that were older than 365 days when they came through. Arundel County has also indicated they've received 10 complaints outside of the portal. And I received that information today. And that information, we've had discussions, which is what Mr. Dave mentioned earlier, that in terms of format, in a way that ensures that it reflects and is consistent with how the PAB will need to receive that information. He's going to follow up and resend that information. And once he does, I will be sure to forward it over to you so that you have that information. But they are all, in terms of the status, they are all currently under investigation. I didn't know if Dave, you had anything to say, or I can just continue with the city of Annapolis. All right, so going to the city of Annapolis, the data that they provided shows that they are currently investigating 13 incidents since July 1st, 2022. However, 7 of those incidents don't involve a member of the public. And in fact, they were because officers had failed to appear in court. So not to make light of this, but any officer that fails to appear in court, I'm pretty confident that the individual that received the traffic citation is likely not going to make a complaint against that officer. Those complaints against that officer failing to appear from court came from the judiciary. But the current status of those, and that information was forwarded over to you, but the current status of those complaints, that they're still undergoing investigation. But it also leads, I had an opportunity to have a conversation with the head of internal affairs from the city of Annapolis, and it leads to the fact that there's so many complaints coming through the pike. And let me take a quick back step. When I say complaints coming through the pike, I mean that under SB that was referenced, under the state legislation that was enacted this year, I want to make sure that everyone is aware that the PAB is responsible for seating members of any administrative hearing board, whether it came in through the public or it was one that was an internal complaint that was investigated. So which is why I just wanted to make sure I brought it to your attention, because this is something that I think, not now, but in the next 6 to 8 months, it will become a bit more voluminous on the PAB's end, which is why the chair and we've had conversations in terms of how do we ensure, because the enabling legislation showed that there were ways to, we want to make sure that workload is not too onerous, and in the event it becomes onerous, that there's the appropriate level of remuneration. But we will follow up on that at a later point. Now, City of Crofton, the Office of the Sheriff, as we just heard, and the Anne Arundel Community College, they've received no complaints since July 1st, 2022, outside of the portal. And again, inside the portal, all of those complaints were directed against the Anne Arundel County Police Department. Any questions on that right now before I move on to the emergency regs?
Hi, this is Danny. Sorry about that. Do
No,
we
you're
know the what type of violations the officer was supposed to be in court to appear for? Was it all just traffic, do we know? Or could it have been something where their appearance left somebody dangerous, like a domestic violence situation or something like that?
My understanding that they were all traffic incidents.
Okay. Thank you.
I think what's a little bit confusing for me is with the Administrative Charging Committee and the Trial Board and Madam Chair are going to be tasked with an inordinate amount of duties going forward. And the remainder of us on the PAB will more or less be giving recommendation by statute. So where a lot of folks are looking at the PAB as being the arm or the disciplinarian or the hammer, we will be operating more or less in an advisory capacity. And then looking at the access to the charging portal, while we were given access to that, when trying to log on, it will say that there's no content available or no information for us. So where are we at in that process? Is that going to stand up later? Or are our responsibilities, duties, role, function going to be more defined by us who are not going to be on the Administrative Charging Committee or the Trial Board, but will be giving direction to those entities?
So 2 questions. Let me quickly first address them. I think the second one that you're talking about is in terms of the Google document with regards to the information. I want to make sure, are you the only person that was not able to see the what was submitted via the portal? And if you are the only person, then I'll ensure that that you have the appropriate level of access to review it. Has everyone else been able to
I have
see it?
not.
Me too.
No.
Okay. What about you, Madam Chair?
Yes, I was able to access it. So I don't know if this is a conversation for the meeting, but I think that might be an email, since it's an administrative function, to ensure that everyone has access. It might just be something to go on the back end with IT. I was not aware that folks did not have access to the information, but now that we do have that, we'll definitely look into it. Thank
No,
you.
I mean, when
definitely.
I spoke to IT has stated that the reason why there had not been anything populated yet is that complaints would have been pre-July 1. But going forward, if there was anything that information would be uploaded, but I haven't seen anything as of yet.
Yeah, but I want to make sure that at the very least, all of the complaints that have come in through the portal that you have access to, and it was my understanding that that was the case. So as the chair noted, I'll definitely follow up and make sure that you all have the appropriate level of access. But your first point in terms of, and I don't necessarily want to go down like a rabbit hole, but you're talking like just generally about the distinction between the ACC and the PAB. And yes, the ACC, when it comes to, they're the ones that will be reviewing, the all of the disciplinary action recommendations coming from all of the various law enforcement agencies within Anne Arundel County. But don't misunderstand what the PAB is doing. It's not just the paragraphs that are enumerated via HB 670 and Council Bill, but a large part of that is, again, seating these administrative hearing boards. And so while there's some processes in terms of standing up, like for example, who will make up these administrative hearing boards? And will it be the same person over and over again? And so those are conversations that I know that with the selection of the administrative charging committee, I know that the chair and members of the board have been looking to resolve that by creating the appropriate pool roster. But that's a very important function in terms of making sure that it's not just the same individual getting seated every time, but that you have the appropriate level of interested residents. That's a very important function. So I'm not trying to diminish one, the PAB over the ACC. Both arms are critical, and just in terms of another thing that you guys will have to do is the next thing I was going to talk about was the annual report. I've spoken with the chair several times, and Jennifer and I have already started doing an outline. I know the Madam Chair has already started doing an outline, just in terms of what has to happen. And the legislation clearly articulates what it's supposed to be within the annual report. But this first annual report is going to be very policy driven. And I hope that I know Madam Chair has been keeping notes of potential gaps in the legislation. I generally have been keeping track of the gaps in legislation, just in terms of from a rolling out implementation stage. And that's something that the board will need to review, because this report is due by December 31st. Now, what I propose is, Jeanette, I think I mentioned, I'm sorry, Madam Chair, I think I mentioned it when we spoke last, but I think next month we should spend a significant period of time discussing that. But I think before that, rather than the annual report reflect what my initial thoughts are, I would love to maybe have one or two members. I don't want to say subcommittee, but I'm a big fan of subcommittees, but have a couple of people who already have a lot of insight that they want to add, so I can meet with them once, even twice, 3 times before at their convenience before the next meeting, so that when we present to the general board or to the larger board, Jennifer and I will have further direction in terms of how you want us to continue to flesh out the annual report. So So I know I spoke for a bit, Dr. Moore, but I hope that answered your question.
You were on point. Thank you so much.
Okay. The emergency regs. As Madam Chair noted, the Maryland Police Training and Standards Commission, they had came out with some emergency regulations. But to give some of you some more context, those emergency regulations were first provided to the Joint Committee on Administrative, Executive, and Legislative Review, which is a joint delegates as well as senates, as well as some state senators. That was provided on Friday, June 24th. And to get their approval, these emergency regs were approved last week. They were finally approved last week by the AELR. They were going to remain in effect until December 31st, 2022. And as you know, under the Maryland Police Accountability Act, the commission is charged or was charged with developing police disciplinary standards, guidelines, and pretty much establishing what the process is going to be under COMAR. So I can send a link over for what is in that document or what is generally in those emergency regulations, but there are a couple of things that are of interest that I want to make sure the board is thinking about. Specifically, it requires the PAB, you guys, and ACC members to maintain confidentiality through written agreements until a final disposition. That's very important because if law enforcement agencies are having hesitancy in terms of providing information that otherwise would be personnel, having this confidentiality agreement in place helps offset some of that trepidation. Office of Law, our attorney from the Office of Law is currently drafting a draft version of that confidentiality agreement. Once it's done, forward it over to the chair, and then it'll go out in due course. Additionally, it requires the ACC, when it's in place, to select a chairman who will preside using Robert's Rules of Orders, and even designates the ACC as public body, so it would be subject to the Open Meetings Act. Under that means that 3 members of the ACC talking would then would mean it's a quorum. Finally, and this is very important, the regs, at least the emergency regs, allows the complainant to waive the PAB ACC process and opt for mediation. And yes. So when I read that, I was a little taken back, but yes, that's something that is currently within the regs, in the emergency regs. Now, whether or not the emergency regs will look the same, remains to be determined. But I just wanted to make sure that some of those points were before your attention. Obviously, it talks about how the NPTSC has created their training syllabus for the ACC, which is a 5-day course, 8 hours a day, and that syllabus is already online. Any questions on the emergency regs thus far?
Just gonna jump in real quick if I can. Thank you so much for sharing that. I had sent out the regs back in August, I think after our first meeting, so I can definitely resend that information to the group with the emergency regulations and the disciplinary matrix. And so what's important to note here is that they are emergency regulations that do have an expiration date. They have a preliminary approval by the legislative body that has to approve such regulations. However, they will likely not change in any substantive manner because what happens is there's a dual process. While this emergency regs are currently in place right now because they were approved, they're also going through the traditional regulatory process in which there's a 30-day public comment period, et cetera. And so, yes, changes can occur, amendments can happen after that regular process, which is happening parallel to the emergency process. But if there are any substantive changes, they have to start all over again, and then the emergency regulations disappear. So I don't know that, that's sort of the intention that the state would want to occur, and then we have nothing. So I wouldn't expect any substantive changes, because then the emergency regs expire and then they have to reissue regulations. I suppose they could reissue new emergency regulations with substantive revisions. We have seen that. We've seen that during COVID. So that is also a possibility and something I'm definitely tracking, and we should be tracking, but I can definitely resend that information for folks to take another look at, because it's a lot. It's a lot of information. Thank you. Were there any other questions?
Okay. I touched on it earlier, the citizen trial board roster. Essentially, the law requires that the PAB select the resident member of the trial board for every single trial board, whether it originated internally or from a comment from a member of the public. Again, there was no guidance given, but Chair Ortiz and I have discussed the need to create a roster of those interested individuals. When we have further discussions, we'll be sure to ensure, because it's not just getting members from the applicants to the ACC, but also creating a roster, creating a public portal to ensure that we can always review applications from interested members of the community. Let's see what else. Oh, a reoccurring question that has come up from the board multiple times, and it's a very understandable question, is the question of reimbursement. And I note that reimbursement is outlined in Bill 16, 2022, which notes that, and especially now that everyone is undergoing a Citizens Police Academy and going out of their way to go to the various locations that these Citizen Police Academies are held. The language notes that voting members of the board may be reimbursed for the expenses incurred related to their duties at the discretion of the executive director, subject to appropriation and availability of funds in the annual budget. I will be the first to say there are funds in the annual budget for this year, so I want to make sure that that you all are keeping track of your mileage reimbursements, so that those expenses, the bill also notes that such expenses may include cost of childcare and transportation necessary to attend the scheduled meeting of the board. And I know that many of the board meetings are now virtual, but again, I know the Citizens Police Academy, there are some mileage expenses that are occurring as a result. Jennifer and I have reached out to the boards and commissions to ensure that we do the mileage reimbursement, or just reimbursements generally, in accordance with how Anne Arundel County does it. We don't want to go and superimpose our process. So we'll follow up with you tomorrow for more information. And I think I touched on most of the chair talked about the personnel changes, and I just want to quickly touch on it. She introduced Jennifer Rogers, but I also want to just note that this is the 4th meeting of the PAB, and prior to my appointment, and I know Dr. Jennifer Purcell, who's the director of special projects, she ran point and was the county's primary staffer, and which is now me. And further, Dr. Purcell's assistant, Courtney Ivy, she's no longer with the county. So I know there's been a level of, in the short lifespan of this PAB, there's been a bit of turnover or change and flux, but I just want to reassure you that we are now settled. We have permanent staff in place, and any rough patches, I think are hopefully behind us, and there'll be smooth sailing going forward. So that's it for my executive report. And if there are any questions on any of the matters I've discussed, please don't hesitate.
Thank you so much for that overview. Are there any member questions? All right, well, we definitely look forward to receiving the additional information. And there will definitely be some follow-up, as Jansen mentioned. We've kind of discussed, I've discussed individually with members about trial board and the need to establish a pool. And we are moving forward, hopefully with ACC selection in the very near future. So I think we are on, we have a really good solid timeline and we're staying within that timeline. So thank you to everyone for all the work that you've been doing in the background, especially reviewing the applications from the ACC applicants. There were many. And so I know that it took everyone's time to go through and review them. So thank you very much for that. And that brings us to the end of the meeting. Is there a motion to adjourn? Y'all want to stay on?
I think everyone's.
Is there a second? Okay. All right. Well, this meeting is adjourned and we will see everyone at the October meeting. Thank you so much. Have a good evening.
Good evening, everyone.